Following the outbreak of COVID-19 in the country, all efforts were centered on how to reduce the spread of the pandemic. However, the Judiciary halted the hearing of parliamentary election petitions until further notice. After lifting the lockdown by the President on 30th July 2021, the Judiciary has now set 16th August 2021 to start the hearing of the parliamentary election petitions rising from the 2020-2021 general elections.
The petitions, according to those guidelines, are supposed to start off on the 16th of this month. How they will start and how they will be conducted is now going to be guided by the Honorable Principal Judge. So the Honorable Principal Judge is going to give other guidelines specifically on how the petitions are going to be conducted. Now that they have set a time frame, we hope that they start on time. We await further directions from the courts on since we have already received the CJ's directives. So we hope that the head of the division will also give us directions on how these and cause lists for the cases, and then we shall be ready to answer to whatever petitions.
Among the petitions to be entertained include the one filed by Shukra Mukesh challenging Nupu's Member of Parliament Joel Senyonyi representing Nakawa East. Although the petitioner Shukra Mukesh had filed his petition in time on 10th May 2021, he later served lawyers from Pase Advocates, making amendments related to lack of academic qualifications by Joel Senyonyi to be a Member of Parliament among other grounds. Mukesh, in the first petition filed in High Court on 9th March 2021, cited allegations of election irregularities, such as reducing his votes, bringing non-registered voters to participate in the voting exercise, as well as ballot staffing. According to records, Shukra Lais Shumuko's original petition was filed on the last date of the 30 days deadline, within which the election petitions were to be filed after being gazetted. However, Kalimani highlights on what is required for one to make any amendments in his or her petition during this time. You have to make the application, and if you make the application and convince the court can allow you to amend. So
amendments are not allowed if they're introducing a whole new case, because what that means is that someone can change their case at will at whatever stage. That means that if there is something that comes to your mind in the course of the case, you can always go back to court. That would be abuse of court process.
Talking to lawyers representing Joel Senyonyi, led by Counsel George Musse, after receiving the petition, they had this to say.
In this case, Mr. Mukesh Babubai, first of all, is way out of time. He filed his amendment on 10th May. Secondly, he did not seek leave of court before dumping these papers in court. Thirdly, he seeks to introduce totally new issues altogether, which were not within his initial petition.
In an election conducted on 14th January 2021, Joel Senyonyi defeated 11 other contestants to be declared a winner of the hotly contested election after obtaining over 31,000 votes. NRM's Margaret Nantongozi were in the second position with 9,450 votes, followed by Kenneth Paul Kakande, and Shukra Mukesh Lais Shumuko, the petitioner, came in the sixth position with only 806 votes. Deborah Namamonde, Nantongo Rebecca, UBC News.